Hello friends, today we will discuss about human rights and social contract, interrelation and contemporary relevance. In this discussion, we will cover what are the human rights and what is the interrelation of human rights with the theory of social contract given by Hobbes, Locke, Rousseau, Kant and Fichte. Let us discuss about human rights first. What are human rights? Human rights are the rights which are inalienable to the human beings. Philosophically speaking, these rights are naturally attached to human beings. Law does not establish human rights. Indeed, these are inherent entitlements accrued in favor of the individuals by virtue of their birth as human beings. A civilized society is always under a constant obligation to ensure the growth of its individuals. Inasmuch development of a society itself depends on the same. Therefore, the linkage between the human rights and the civilized society is inextricable. Through the instrument of law, a society discovers various kinds of interests and classifies them under the categories of private interest, social interest and public interest. The purpose of identifying these interests, according to Dean Roscoe Pound, is to ensure that society is not only preserved, but also progresses. Hence, the interests which can contribute in sustaining the existence and place the society on the path of development are recognized by law, and after recognition by the society, these interests are addressed as rights. Against this backdrop, an attempt has been made in forthcoming discussion to underline the relationship between human rights and the theory of social contract and relevance of both in modern times. It gives an opportunity to think if there is a need to reshape the content of Charter of Human Rights in contemporary times. So far as human rights are concerned, Harold Laski observes that rights are those conditions of social life without which no one can seek in general to be himself at his best. Human rights, especially in post-World War II scenario, are the standards of quality of governance. According to Justice J. S. Verma, the linkage between human rights and human development is universally proved, and the state of human rights in a society is an evidence of quality of governance in a state. The adoption of Millennium Development Goals, Sustainable Development Goals and the underlying spirit therein clearly depicts the relationship between good governance and human rights. Without ensuring the respect towards human rights of human beings, the concept of development is futile. So friends, now let us discuss about social contract that was entered into by the humanity to recognize and protect human rights. The concept of social contract originated in the phase of human life when they neither had government nor law. People were living in the state of nature. To ensure self-preservation, the men entered into a contract with each other, as the basic instinct of man is to crave for peace. The human beings are born free and enjoy equal liberty bestowed by the nature. Till the freedom is enjoyed equally by all of us, no friction occurs. However, the utilization of liberty through the very talent, determination and virtues, the outcomes are bound to differ. According to Plato, irrational appetite for personal gains, egoistic passions and false beliefs drive man towards vicious circle of power and identity game. The emergence of these differences result into friction and places the men against each other. Here, law is required in a civilized society owing its existence to social contract. The views of various jurists on the significance of human rights in context of social contract are that we will divide into three classes: ancient era, medieval and modern period. In ancient, we will discuss about Plato, Aristotle and Cicero. Plato, in his famous work The Republic, mentioned that government exists for the benefit of all citizens and all social classes and must mediate between potentially conflicting interests. The sovereign is a mediating force to ensure an atmosphere to its people doing one's own work and not meddling with what is not one's own. The purpose of such a mediating force means government is to provide an opportunity to all persons for happiness. Plato encapsulates the happiness of the whole city not as an abstract concept, but happiness of the greatest number, rather happiness of all citizens derived from a peaceful, harmonious, cooperative union of different social classes. Political authority of philosophical ruler laid down by Plato does not lie in rationality, but in substantive morality as well. To say in other words, the consent of the governed. Now, let us discuss about Aristotle's contribution to social contract. In his famous work The Politics, he observed that the government which have regard to the common interests are constituted in accordance with strict principles of justice and therefore true forms, but those which regard only the interest of the rulers are all defective and perverted forms, for they are despotic. He further elaborated that tyranny and freedom are antitheses of each other. Aristotle's work revealed that a society can have only one thing out of tyranny or freedom, as tyranny is the very reverse of a constitution. Law will be respected as supreme if it administers justice without having a breeding surface for tyranny. He expounded that rulers must be the servants of law, because law is order and the good law is good order. The law shall be of no avail if these deprive opportunities to the governed to grow. Then Cicero. He is also known for his work published under the title The Republic, where he underlined the relationship between basic rights, law and society. He opined that for a just state there should not only be laws, but liberty and equality are equally indispensable. He further justified that existence of a sovereign power in government to preserve the existence of liberties. Cicero made it categorically clear that ideal form of government has to uphold natural law, establishing justice and ensuring liberty to do what ought to be done and forbids the opposite. Let us move to medieval era. Modern concept of social contract has its strong roots in medieval times. Marcellus of Padua, an Italian scholar known for his famous work, The Defender of Peace, conceptualized sovereignty in people. Laws promoting sufficiency of life are most likely obeyed. Marcellus observed that earlier men lived in a state of nature with neither the government nor law. Men entered into an agreement for the protection of their lives and property, and thus society came into existence based on twofold agreement. First, they undertook to respect each other and live in peace. Second, they resolved to obey an authority and surrender the whole or a part of their freedom and rights, and the authority guaranteed every one of them the protection of life, property and to a certain extent liberty. This resulted into the evolution of the government or the sovereign power. Therefore, the basic source of the political power lies with the people. Then comes Hugo Grotius, who is known for his commentary on the law of price and beauty. He explained the social contract by insisting that the people give their rights to a ruler, receiving a peaceful and stable society in return. This agreement served two purposes. So far as internal governance within a state was concerned, the people had an absolute duty to obedience to the government, and secondly, there should be some basis for legally binding and stable relations among the states. He focused more on stability and orderliness of society, ignoring the restrictions to be imposed on the ruler. Grotius denied that the government is for the benefit of the people, while Hobbes, who is the author of Leviathan, attached great importance to the state authority. He mentioned that in a state of nature, man lived without a common power to keep them all in awe. It put them in a condition of perpetual and devastating war against each other, threatening their lives. The natural dictate of self-preservation and desire to absolve them from the clutches of permanent insecurity led them to transfer their rights to the ruler. The ruler was not placed under any obligation except to keep order. He supported the idea of sanction and concentrated all authority in one single form, in sovereign. Therefore, the desire of self-preservation and cravings for peace by subjects made the sovereign invincible. Hobbes defined injustice as nothing else than non-performance of covenants. The nature of justice consists in the keeping of valid covenants which start with the constitution of a civil power sufficient to compel men to keep them. Then let us discuss about John Locke. He is known for his famous work, True Treatise of Government. He asserted the idea that basically man by nature is free and equal. He recognized the existence of rights such as right to life, liberty and property, independent of the laws of any particular society. Thus, these can be neither given nor taken away by the states. Locke propounded the idea that freedom and equality of men is at the foundation of a legitimate political government through the theory of social contract. The perfect freedom and uncontrolled enjoyment of all the rights and privileges of law of nature equally with other human beings living in the same society needed some institution for the protection against any kind of deprivation, injury or loss caused by others. According to Locke, people repose their few rights to the government in order to secure the peaceful, joyous exercise of their basic freedoms covering life, liberty and property. Locke laid the basis of this edifice of social contract theory on the foundation of rights of the people and cautioned that government exists by the consent of the people in order to organize and protect the interests of the people and promote public welfare. No political regime in modern times can sustain its existence without the trust reposed by the people in lieu of the protection offered. So, any kind of transgression has to be condemned by the politically civilized society by way of declaring it an offense and imposing punishment on the offenders. Failure in protecting the basic rights of the people may result into substitution of the government with the alternative. Therefore, the community of states does recognize these rights at international level and intranational level, between the nation and within the nation, so that human beings can live their life in a meaningful and constructive way. In this way, the individual was now placed in the center and invested with inalienable natural rights, among which the right to private property was the most prominent. Locke presented social contract as justification of the existence of government, placed the government under the duty to preserve the trust of the people by protecting the rights of the individual. The subjects vested their power in a government whose function is the protection of the individual, so long as the government is faithful to its pledge. It cannot be deprived of its power. So, in this way, if we look at Hobbes, he advocated for authority. If we look at Locke, he stood for liberty and protection of rights of the people. Let us discuss about Rousseau. Rousseau, in his famous work The Social Contract and Emily, stated that every human being had unlimited liberty, and earlier there was nothing like private property, competition or jealousy. Man lived life of a savage, being unaware of difference between right or wrong and notions of virtues or vice. Basically, man was innocent. However, according to Rousseau, this phase did not last long. Increase in the population and development of reason brought about a transformation as agriculture and metallurgy become the central activities of life. It resulted into disappearance of simplicity and happiness. Reason pushed them to collect and take the things under their possession. The stronger and skilled people did greater work and earned more wealth. The inequalities in income led to the evolution of concept, mind and thine. It made life intolerable, and decisions were taken on the basis of physical might. There was utter chaos and anarchy, which sown the seeds of formation of an association to protect the person and property of each associate with whole common force, and return of that everyone resolved to stay united through social contract. So, friends, one more important point worth mentioning here is that Rousseau distinguished himself from other thinkers, Plato, Aristotle, and then Cicero, Hobbes, Locke, and he distinguished himself as he proclaimed that liberty, equality and property are rights of the citizens, not natural and inherent of the individual. According to Rousseau, liberty is civil liberty, not natural liberty. Men are equal by law and not by nature. So, this is the way that Rousseau distinguished himself. Now, let us discuss about Kant. He introduced the idea of proclamation of the autonomy of reason and will. He gave more importance to human reason and observed that law is created by human reason. Law is the complex totality of conditions under which maximum freedom is possible for all. The sole function of the state is to ensure observance of law. Most important contribution of Kant is that he clarified that individual should not allow himself to be made a means to an end, as he is an end in itself. He subjected political power to function as protector and guardian of that law. Fichte laid the base of his theory of social contract on twofold contract, property contract and a protection contract. He viewed property as an emanation of personality. So, to sum up about the medieval period, the contribution of Hobbes, Locke and Rousseau, it can be submitted that according to Hobbes, the purpose of a government is to impose law and order to prevent state of war, while Locke said that the government has to secure natural rights, and Rousseau gave weightage to live in harmony with each other. Let us look at modern perspectives. The humanity re-entered social contract in 20th century after witnessing 2 world wars. The states after the Second World War resolve that the peace, progress and prosperity should be the ultimate goal of governments around the globe. The adoption of United Nations Charter, Universal Declaration of Human Rights and various other covenants are the instances of rewriting the terms and conditions of modern social contract in the form of these basic and inalienable rights. The countries having obtained independence from their colonial rulers framed their constitution and incorporated almost all their rights in their constitution and other laws. A precise discussion to explain the landmarks is like universal perspective. So, adoption of Universal Declaration of Human Rights 1948 on December 10th in aftermath of Second World War is an instance of revisiting of social contract wherein all the members of United Nations agreed to a declaration of those human rights to which all human beings are entitled. The purpose of this declaration is to ensure the respect for basic rights of human beings on the universal level. The significance of this declaration lies in the statement aiming universal respect for human rights as the common concern of all governments and all people. The declaration enumerates the standard for evaluation of the attitude of the societies and governments. Most remarkable feature of UDHR is mentioned in the preamble to the declaration, wherein the freedom from fear and want has been proclaimed as the highest ideal in the interest of common people. All other freedoms originate from this basic focal point of life, freedom from fear and freedom from want. So, friends, the states have to justify their existence by ensuring freedom from fear and freedom from want, so that the individuals can be spared to exercise their liberties for the development of their personality to the fullest extent. Let us look at the Indian perspective. The preamble to the Constitution of India spelled out lofty aspirations to protect life, liberty, dignity, to realize justice, social, economic and political. In pursuance of these goals enshrined in the preamble to the Constitution, Part 3rd and Part 4th enumerate fundamental rights and directive principles respectively. These are in the form of obligations on the state not to take away or abridge the fundamental rights of the individual. It further implies that the duty is cast upon the state to ensure creation of such an atmosphere wherein the people can excel in individual as well as collective domain of activities and strive for excellence in their endeavor. So far as contemporary perspectives are concerned, the contemporary challenges in 21st century have compelled to revisit our Charter of Rights to protect life, liberty and property of subjects. In 21st century, the issues of privacy, digital gap, guarantee of human rights during disasters are the areas of serious concern and thorough deliberation. Look at this. The advent of ICT, information, communication and technology has made the life, liberty, property and privacy more vulnerable than ever before. Without privacy, life is deprived of its dignity and self-respect. Due to this borderless cyberspace and emergence of the concept of global netizens, the protection of property along with privacy and life is prone to violation by offenders in cyberspace. Similarly, the concept of distributive justice in context of right to education is affected due to digital divide in the age of online lifestyle. Furthermore, the guarantee of life and liberty not only against external powers or aggression, but even against a small pathogen presented a new challenge before the whole fraternity of nations and want a revisit. To sum up, in view of foregoing discussion, it can be submitted that human rights and social contract are interconnected. The theory of social contract has its roots in the right of self-preservation and freedom from fear that gives birth to numerous human rights. With the passage of time, the relation between human rights and social contract has grown stronger, but the constant revision of the scriptures of social contract at municipal level, national level, regional level, international level and universal level through bilateral and multilateral instruments have made it a concept of discussion not only in academics, but in governance and polity across the globe. The concept is still relevant as it was at the time of origin. Entry of humanity in new millennium with the digital revolution has made geopolitical boundaries useless. Therefore, the need of contemporary times is to revisit the social contract and its constituents in the light of borderless world, turning the whole globe into a global habitat. The governments around the world are seriously deliberating to reset its terms and conditions in the post-pandemic era. So, friends, we have discussed about the social contract which came into being to protect the rights of individual as expounded by Plato, Aristotle, Cicero, Hobbes, Locke, Rousseau, Kant, Fichte and we all. I hope that this discussion would be useful for you and the topics must be clear. Thanks for your patience and careful listening. Thank you.